Next case that is set for argument this morning is Charleen Sullivan versus Mark Sullivan. The case number is 29070. Each party will have 15 minutes to present your arguments. Now, if the appellant wishes to reserve time, you may reserve up to 5 minutes. Just let me know and I'll keep track of time and let you know as you get close. The arguments are being recorded, as you know, so please keep your voice up and remain at the podium. And we've read the briefs and are ready to proceed if you are.
Good morning, Your Honors. May it please the Court, I am Jack Hindenburg. I represent the appellant, Charleen Sullivan. May I please reserve 5 minutes for rebuttal?
5 minutes? Yes, you can. Thank you.
Okay, the facts in this case are relatively straightforward. Charleen Sullivan and Mark Sullivan were divorced on May 25th, 2018, after a trial was held on October 10th, 2017. Almost all of the marital and separate property was stipulated to, except for the valuation of 2 vintage Ford Mustangs, which were acquired during the marriage. The valuation of said Mustangs was one of the 2 main issues for the trial. The other issue for the trial was the amount of spousal support. In the trial court's judgment entry, the court awarded wife spousal support in the amount of $35,000 a year, or just under $3,000 a month. The trial court arrived at its award by equalizing the parties' incomes. This was done by imputing wife's income in the amount of just under $20,000 based on what she made in 2016 with her primary employment and a second job. For husband, this was done by imputing his income $57,699 less than what he made in 2016. The first assignment of error before the court is a question of whether the trial court abused its discretion in wife's spousal support award. In awarding spousal support, courts are bound by the statutory provisions of the Ohio Revised Code. Ohio Revised Code section 3105.1AHC provides in pertinent part that in determining whether spousal support is appropriate and reasonable, the court shall consider the following factors. Then outlines 14 different factors, a few of which I'm going to focus on today. One of the factors is the income of the parties from all sources, including but not limited to income derived from the property divided, dispersed, or distributed under section 3105.171 of the Revised Code, the relative earning abilities of the parties, the duration of the marriage, and the standard of living of the parties established during the marriage. Further, Ohio Revised Code section 3105.18C2 provides specifically that in determining whether spousal support is reasonable and in determining the amount in terms of payment of spousal support, each party shall be considered to have contributed equally to the production of marital income. In the instant case, the trial court abuses its discretion in awarding wife spousal support based on imputing husband's income at $102,000, where the evidence established that husband earned $157,699 in 2016, $148,378 in 2015, and $134,487 in 2014, for a 3-year average of $146,855. The trial court's determination of husband's income for purposes of the spousal support award was an abuse of discretion in that the court weighed improper factors when coming to its conclusion. Specifically, under 3105.18c, the trial court is to consider, as I mentioned prior, income from all sources, which would include husband's bonus income. The testimony in the trial indicated that over the last 3 years, husband's bonus income was substantial and recurring, averaging, as I mentioned, about $146,000. I'm sorry, the bonus averaged, in addition to his income, $146,000. Even if the court were to be justified in its exclusion of husband's bonus income, the court still erred by its failure to examine more closely husband's earning ability, given that the evidence established that he was capable of earning much higher than the $102,000 base salary.
Wasn't there testimony that he was in the process of retiring or planned on retiring shortly?
If I recall, there were some comments made about the thoughts of retirement. As far as I'm aware, at the time of the trial, that process wasn't in place. It was just thoughts that he had that someday he would like to retire.
Did the court address that in its entry?
I believe that was mentioned in the entry. It was a long entry. I think it was about 58 pages long. I think it made reference to he was thinking about at least finding a new job at one point, but as far as I'm aware, he's still employed at the same job. But, you know, all I'm going based off of is since 2010, his earnings were above the base that the trial court used of $102,000.
Thank you.
The court also abuses discretion by giving an improper factor weight, namely that the income contribution husband made to the marriage was of his own extraordinary work rather than the parties' equal contribution to marital income as is expressly required under 3105.18C2. The trial court stated that wife works less days per year and hours each day as compared to husband, and that wife's career path is her choice, and the husband shall not be required to pay his bonus income to wife, which is a reward for his extra time and effort he puts into his job, as such will be unfair to husband. Specifically, the court found that it would be inherently unfair for the plaintiff who works 186 school days, which is less than a normal 8-hour working day, per a year to reap the benefit of the defendant who puts in 12-hour work days year-round. In order to balance that inequity, the court stated in its judgment entry that it shall level the playing field by imputing income to plaintiff based on her 2016 income in which she worked a second job during the summer and not including defendant's bonuses. While a trial court is permitted to examine equitable considerations in awarding an amount of spousal support, the court is guided by specific statutory factors, including determining the party's income from all sources, party's earning ability, and most importantly, that each party is considered to have contributed equally to the production of marital income. To have failed to give proper weight in determining husband's income from all sources, as well as his proven earning ability, and to very specifically disregard the mandate of 3105.18C2, that each party is considered to have contributed to marital income equally, the trial court lost its way as it does not have discretion to disregard the statutory mandates of control spousal support. That was a quote from Palazzo versus Palazzo, citing Cherry versus Cherry, an Ohio Supreme Court case. The second assignment of error before the court is a question of whether the trial court erred in its valuation of the parties' Ford Mustangs and its property division award relative to said Mustangs. In a divorce proceeding, courts of common pleas in Ohio have full power and jurisdiction to equitably divide the property of married parties upon their divorce. This is pursuant to Revised Code 3101.03, 31.05.01, and 31.05.011. The trial court is charged with the duty of valuing and distributing all property rights of the parties, marital and separate. 31.05.171B specifically provides that the trial court must make a determination of what is marital property and what is separate property and divide such equitably. Marital property generally includes all personal property that is currently owned by either or both spouses and was acquired during the marriage. Each spouse shall have considered to have contributed equally to the acquisition of marital property. It does not include separate property, which is defined as any gift of any real or personal property that is made after the date of marriage, but which is proved by clear and convincing evidence to have been given to only one spouse. The party that is seeking to have a particular asset classified as separate property has the burden of proof, by a preponderance of the evidence, to trace the asset to separate property. This is pursuant to I can vary versus I can vary.
There's no argument at the trial court level that the Mustangs are separate property, correct?
That's correct. However, the division, I'll get into that portion a little bit later. The argument at the trial court was that because of the time and effort that the husband put into this vehicle, they kind of disregarded it as a marital asset, any appreciation that the vehicle had during the course of their marriage, and determined that since its appreciated value was because of his hard work and effort, they should go back to the purchase price of the Mustangs and split that equally.
What of the appellee's argument about how the calculations don't work out to either the purchase price or the appraised value, that it's a hybrid type of, and it's not, as the plaintiff says, it's not a result of going back to the purchase price?
Going back to the purchase price, I mean, I think it can be argued that there's no way in which these Mustangs are worth the same that they were worth when they were purchased, and that it's fair to assume that they've appreciated in value, in large part given that the husband put time and effort into making improvements on the vehicle, but that was also improvements made with marital funds. And if they're arguing that it was made by separate funds, it's their burden of proof to prove that it was separate funds which went towards the improvement of the vehicle. There has not been an attempt to show that it was separate funds that went towards the improvement of the vehicle, which is their burden of proof. And given that, it has to be assumed that it was marital assets and marital funding that went towards the improvement of the vehicle.
And the appraisal that White had done, that was stipulated to or not?
I think there was a $2,000 disagreement. I can't recall offhand if the full appraised purchase price of the two vehicles was stipulated to. I don't think that it was argued that it was, far off the appraised value that the parties, or that the plaintiff came to with regard to the two Mustangs.
Okay, because you just said exactly what the trial court's interest says that confused me. You said, I don't know if it was stipulated to the purchase price of the two appraised vehicles. You have the purchase price.
Right.
I'm assuming that was, or I don't know if that was stipulated to what the purchase price was. And we have the appraised value. I don't know if that was stipulated to. It seems in some parts of the entry, it's all the same. We're talking about a stipulation that encompasses all of those values.
I wish I remembered 100% offhand if the appraised value was stipulated to as to the two vehicles or the purchase price of the vehicles. I do see that confusion because it goes back and forth a little bit in the judgment entry. So,
Counsel, you got a total of 3 minutes and 40 seconds.
okay, thank you. That's
Keep
for
arguing, or do you want to reserve that?
that's for the 10 minutes or for the 15?
That's for the entire,
I'll
that's your
reserve.
rebuttal.
I'll reserve what remains.
Okay, you'll have 3 minutes and 40 seconds left for rebuttal.
Thank you.
Thank you. Attorney Meyer, then you'll have 15 minutes.
Thank you, Your Honor. Good morning. May it please the court. To begin with, I find myself in somewhat of the unfamiliar position as the appellee's counsel. To stand before you today, since we have no cross assignments of errors or cross appeals, to justify what the trial court did in this particular regard. And in that regard, let me start with kind of where counsel has left off, and that was at the Mustangs, and in terms of the property division, which is what the judge divided first before we moved into spousal. The argument being made, and I see it more than just the value of the Mustangs, and Your Honor is correct. There were two appraisals stipulated to on the Mustangs for a total value of $51,000. 38 on the 67 Mustang, 13,000 on the 66 Mustang. Mark in testimony thought the 67 was worth 35. He thought, or he testified to, that the cost to acquire, now that's a different sub-issue to this, was $8,000, not $6,000 on the 66 Mustang. Judge Cook used $28,000 as cost to acquire. When you look at her entry, page 43 of 44, when she discussed the factors of spousal support for the second time in her entry, she addressed $14,000, one half of the 28 cost to acquire on the Mustangs, put that in her column, a part of the overall property division. Ultimately, later, she found the full value of $51,000, their appraised value, going in the Mark's column. Now, when we were at trial, so he's essentially taking the full appraised value of that. That's just how the property division works out. And it works out this way for one basic reason. We stipulated two appraisals We put evidence on as to cost to acquire, but ultimately, it was Mrs. Sullivan's decision that he could have them. Now, I could stand here and say that indirectly that's a gift. After all, they were marital property. We're not debating any of that. They were appraised. Even the issue of what it cost to either maintain them or restore them, it's blended into what the appraised costs were that we received in this matter and that we stipulated to, 51 for both of them.
She agreed Mr. Sullivan can have the cars, but wanted one half of its appraised value, I think.
Right, 51,000 went into his column, Judge, for the appraised value of those cars. Now, if you were to divide that in half, I don't think we're too far off of where the numbers would be. Again, depending upon whether you back the cost of 28,000, Judge, out of the 51, cost to acquire minus what they sell for, leaving a net of 28. It gets a little confusing.
Right, well,
It leaves a net of 23, I'm sorry.
you yourself said the appraised cost,
Right.
so that's,
And Your Honor, that's an opinion as to that.
no, but that's the struggle with the judgment entry,
Mhm.
because cost is not value,
Right.
and value is appraised. Cost is either agreed to or disputed.
Right. Moving forward from that issue was the further discussion that after the property division was summed up, and I believe the numbers the judge came up with was $566,000 in property division. When you tally half of his 401K, which was $301,000, her share of an Ameriprise account, which was $172,000, the value of the marital home, which also was stipulated to, as well as the Mustangs. And she also kept the 2007 Chevy Silverado worth $8,000. We didn't debate that, we didn't ask for half of that $8,000. When the court assessed what Ms. Sullivan was left with in terms of property division, it isn't as if it was also a finding by her that that was income that she could draw on. The court basically referred to it as savings, in a sense. Rainy day fund, money that she could ultimately use because it was readily available and could help her with her expenses. Much was debated about at the trial court, or much was talked about of what her monthly expenses were at $3,000 a month. Part of those expenses included housing expenses for their adult son away in Memphis at college, $600 to $1,200. I think the global point, though, about even her expenses is that it's not a listed factor. Expenses. You consider it, you look into things, but it's not one of the 310518 C1 factors. It's could come in under any other relevant factor at the end, and the court did consider everything. That's the crux of the argument, too, in terms of the spousal support here. Imputation of income. There isn't any real guide, case law, or through the statute of what you do with income. You consider income from all sources. Child support would lock us in, Your Honor, under 311901 when we do child support as to what is a person being underemployed or voluntarily unemployed. And there's a whole laundry list of what you would consider if you were giving your child support.
Counsel, you just said you consider income from all sources.
Income from all sources.
But didn't the court exclude some pretty hefty and reoccurring bonuses? Wasn't like a one-time, $2,500 or even $20,000 bonus. They seem to be pretty consistent.
Well, the bonuses, Your Honor, are not guaranteed. Mr. Sullivan works for Unilock, which is a seasonal landscaping products company.
But he got one in 2016, 15, 14.
Indeed he did. But Your Honor, at the lower court level, she did consider that. And then her argument or her rationale for it was leveling the playing field and using his base salary of $100,000, which is still 5 times the salary of Mrs. Sullivan. When you let it actually sink in that it's a seasonal landscaping business, then honestly, you're looking at really a market for him that is thriving, which is the spring and summer. So he does not find out until every December what his bonus will be. Not until December will he find out. And honestly, and factually, he wouldn't get paid on that bonus in January, February, or March either. That was established in the record. So any amount higher than the $2,900 a month here that was ordered, which by the way, is only $100 shy of her own estimated expenses of $3,000. Any amount greater than that in the months of January, February, and March could potentially set him up if he doesn't do something financially himself for having not enough to meet his own ends for those months. And that's a critical distinction or a critical matter to consider here. Mr. Sullivan has been with Unilock for 28 years. Mrs. Sullivan has worked for 14 of the marriage for a part-time job, 20 hours a week, as a teaching assistant in the Springfield schools. Mr. Sullivan puts in 60 hours a week, 6 a.m. in the morning, 6 p.m. at night, drives everywhere to do his job. At this rate, we're still asking him to continue to do that. Your Honor had mentioned, is there a point in time where at the ripe old age of 50, 52, 53, will he be thinking in the future of slowing down?
I struggle with 52 and 53 being either right or old, but we'll let that one.
Did the
Well, we hit the
trial,
wall at 50, we're definitely on the back nine, but,
did the trial court maintain continuing jurisdiction on
Yes,
this
ma'am.
lawsuit?
yes, ma'am. And I think that's part, obviously, that's part of the reason, because he will have to continue to work at this rate to pay the $2,900 a month to Ms. Sullivan. This was not a case, Your Honors, where this was a lavish or extravagant lifestyle, where either party really came forward and said, continue to maintain me in this lifestyle after we're divorced. 2 vacations a year, lived rather modestly. That was a joint decision that they made together 28 years ago when they got married. He is now faced with the prospect of continuing to come up with $2,900 a month into the foreseeable future when he would like to work less.
Have you,
Well, go ahead.
have you encountered a case that says that you're going to impute income, you're gonna use those terms, imputing income to a lower amount versus I'm gonna say that the person, you know, for instance, her imputed income is a higher amount than the numbers show? The term just gives me pause because I don't know that imputed income, in other words, what the trial court says is, I'm just gonna say he in reality only makes the base salary. Imputed for the purposes of spousal support doesn't make a whole lot of sense going in the opposite direction, does it?
I think when you put it that way, perhaps not. However, I think when you look at the unique facts and circumstances of each individual case, if you're talking about imputing, if you can impute lower to higher, you could also impute higher down to lower. And I guess to sustain the reasoning behind what you would be doing that for would be because you believe bonuses aren't the same as salary increases, or bonuses are treated differently, or bonuses just aren't a guarantee. And that if they can be taken away at any time, you're either setting yourself to come back in because of, as Your Honor says, continuing jurisdiction to come back in and modify it, which would certainly be a reason to do so if he lost a bonus through no fault of his own. Seems to me that if you're going to pay me more, Judge, as a salary increase, that's more of a guarantee than what a bonus is. But imputation, I believe, you're right, goes both ways, lower or higher, because in a sense, there really isn't any guidance statutorily under 3105-18C1 or anywhere in there to do it up or down.
There is some case law that says that in a spousal support determination as opposed to the child support determination, you can't impute income, it is what it is. Just use the numbers.
That's correct, but then you get back to the issue of what other tools you're using to do that with, whether it's the FIN plan, and boy, we've seen where that has taken us sometimes as far as it handcuffing you mathematically to what the number may or may not be. I prefer not to look at it this way, but I prefer to see spousal support in terms of what is reasonable and what is appropriate under the circumstances within the language of the statute and within the language of the case law that would interpret all of these different factors. And as long as the court has applied them and not placed any unreasonable reliance on any one of them, I believe whatever rationale she's used, unless you find it to be arbitrary, unreasonable, capricious, unconscionable, that the decision stands. You can disagree with it, but beyond disagreeing with it, you're going to have to be able to frame an argument in terms of how unfair or how unreasonable it is or it is not. At this point, it's still $2,900 a month coming out of Mr. Sullivan's paycheck every month, month in and month out, until he does get to a point where he doesn't have to work the 60 hours a week. And in some respects, we're looking at equity. We're looking at a judge here who applied the factors, saw that Mrs. Sullivan was working 20 hours a week, heard testimony from her that she wasn't interested in working anymore, or in getting any advanced education beyond Mark. She has a college degree, he has a high school diploma in the Marine Corps. So the factors were weighed, which is why there was a bottom line decision to come up with the number that she did in terms of the monthly amount of spousal support.
Which is almost exactly in between what she requested and what he was willing to pay,
Right. Right, when we came, our offer was 2, theirs 44, she essentially came down in the middle. And the thing of it is I don't think you can average, I don't know if that would be an actually correct way to do it, but I don't think she did. I think within 52 pages of this opinion, she went through the factors twice, all 14, and then the other additional factors, taking great pains to lay out what she found as to be reasonable and important. And yes, Your Honor, as to imputation, she did use words like, let's level the playing field. But you know what, when I read that as a person trying to do equity, trying to be fair. I don't read that to mean that it should be my basis, my judgment of what's equitable and what's fairness. It's her judgment. But to actually write that and put that in there, it tells me that's a person considering this. Taking it. Sorry. Same thing with the bus rules. Thank you.
Thank you very much. And counsel, you have 3 minutes and 40 seconds on your rebuttal.
Thank you. May it please the court. Your Honors, first thing I'm going to speak to quickly is the issue of the bonus. I think I might have mentioned this prior, but I just want to reiterate. It was mentioned that the bonus is not a guarantee. However, it does seem more likely than not that he will continue receiving bonuses at his current place of employment. Going back to 2010, looking at the amount of income he was stated as having by this court, the amount that they imputed him as having of $102,000, he has made more than that since 2010. So to say that that's his imputed income, when it's been higher than that since the year 2010, when you include bonuses, I do not think that it is a fair way to impute his income. Secondly, as to more issues of the spousal support as it relates to the property division, in awarding wife spousal support in the amount of $2,916.67 a month, the trial court specifically stated that said amount plus wife's monthly earnings will have wife living on $3,882 a month, which is well over what she had for monthly expenses. The trial court's reasoning is flawed under the applicable law. First, pursuant to this court in Palazzo versus Palazzo, any property division payments cannot be considered as income for spousal support purposes, which are defined by statute as support and sustenance. So the reference I was made to a rainy day fund, which she would be getting from the division of the property, to argue that she should be receiving less in spousal support would run contrary to this court's reasoning in Palazzo versus Palazzo. While the trial court cites the 5th District Court in the Hutta decision, Hutta is not binding law on this appellate district, but rather is in direct conflict with the case law from this appellate district. which has held that it is not permissible to combine the two difference determinations. Furthermore, as Palazzo mandated, Ohio appellate courts have consistently refused to require the party receiving spousal support to invest his or her portion of the marital property division in order to reduce the need for spousal support. Here, this is exactly what the trial court has done. The trial court reduced the amount of spousal support wife would receive based on the actual income levels of the parties, instead finding that wife did not require as much support because of her property division award, but without regard to the additional funds husband himself would have based on his property division settlement in the same amount of life.
Got 1 minute.
Thank you. To conclude, the trial court in its judgment entry for the parties' divorce erred on several grounds, so much so that taken as a totality of their circumstances, the matter should be reversed and remanded. The trial court abused its discretion in awarding wife spousal support when it excluded husband's bonuses and determining his income for spousal support purposes, and determined that his bonus income was a result of his own extraordinary efforts rather than from the equal contribution of both parties during the marriage. In addition, the trial court erred in its property division award, specifically by using an incorrect valuation date and amount for the parties' Ford Mustangs, which resulted in an unequal and inequitable property division award to wife. Accordingly, appellant respectfully requests this honorable court to reverse the decision of the trial court and remand the proceedings for further determinations. Thank you.
You have 2 seconds left. You did a nice job wrapping that up. Thank you both of you for your arguments this morning, I should say. The court will take this matter under advisement as well, issue a decision in due course. The clerk of courts will mail a copy of this decision to each of you on the day it is released. Opinions are also posted on Supreme Court of Ohio's website where you can check for them there. Thank you